Well, good afternoon, everybody, and welcome to our HR Policy Association Global presentation on understanding the psychosocial risk regulations in Australia. My name is Michelle Swindon. I'm the Director of Affairs for Asia for HR Policy Global, and I'm so pleased to have so many of our members from across Asia and, in fact, from around the world joining us today. Because we actually have quite a number of people joining our meeting today who are new to some of our webinars, I thought I would just spend a minute giving you a little bit of background about the HR Policy Association, of which all your companies are members. The association was established actually back in 1968 as the Labour Policy Association and changed its name in the early 2000s. And today it is the preeminent body representing the CHROs of more than 400 US companies and multinational corporations. As I said, your companies are all members, and our association has regular contact with your CHROs, regardless of where they sit in the world. Sorry, it's very loud here. The responsibility of our organisation is to provide networking, research training. Particularly in the US, we are a public policy organisation, and we do make representations to the US government on issues that are relevant to human resource practice and legislation in the US. HR Policy Global was formed in 2021, which it brought together some groups that perhaps you're all familiar with, and that is BIG, APIRG, LAMERG. We were all operating independently as separate groups, and we've come together for the last couple of years under HR Policy Global. There are, of the 400 companies who are members, there are around 94 predominantly multinational corporations who are members of our global group. And it really does provide a unique opportunity for you as HR professionals to network and learn and contribute. So I'm very quickly going to introduce, because really we've got Adam and Noella who are going to really take us into the core of the discussion today. But I just wanted to position with you what we mean when we talk about psychosocial risk factors. And what's quite interesting is that the ILO had a definition as far back as 1984. And we really are talking about those factors that referring to the interactions in the work environment, the job content, capacity, culture, extrapersonal considerations that really do impact somebody's ability to work, their health, their job performance, and their satisfaction. But what's really important here is to understand what the scope is of what we're discussing today, because although the ILO had a definition as far back as 1984, it really is only in the most recent years that countries are putting compliance and legislation around that definition. And what's important is that we are referring in the scope to those factors over which the employer has an influence, has a liability or legal obligation, or has some form of management power. And that's really important to understand, because I saw a very good example, and they said employees in their personal lives can be very stressed about all sorts of things. They might have issues happening with their family, they might be selling their house, they've got stuff going on. That's not the domain, and they may bring that stress to work, but that's not the domain of the employer to manage the stresses that a person is experiencing outside of the workplace. So really the scope is looking at what, as an employer, you have influence, management power, or a legal liability or obligation to be managing. I'm not going to go into a lot of detail here, so I will just let you have a quick look at the screen. But when we talk about the range of factors, it really is quite broad, from job content to working time to working hours, to the level of control that somebody has over the work they do, to their role in the organisation and what expectations are placed on them. And that is really interesting when you think of their role. Is it not just work that's high value and high powered, but it's also the impact of low valued and repetitive work on employees. Looking at the interpersonal relationships is certainly one, and Adam and Noella are going to go into a little bit of detail as well today over changes in sexual harassment, but this is one of the areas that we do tend to have a focus on around harassment, bullying, victimisation. And so when we talk about the I guess, the impact of psychosocial risk factors, we really are looking at the overall framework, and that is how do those factors lead to a consequence for employees? How does exposure lead to risk? And then finally, what are the final effects that those risks can have on our employees? Some of this information, if I can just recommend to you, has come from a very, very good module that the ILO have produced on building modern and effective labour inspection systems. It's module 14. So if you do want to get a little bit more information on the ILO's perspective on psychosocial risks and hazards, that's a really good thing to refer to. So without further ado, I'd like to pass over now to our guest speakers, and I'm delighted today to have both Adam Salter, who is a partner at Jones Day in Perth, and Noella Silby, who is an associate from Jones Day in Perth. And Adam and Noella are good friends to the association. We thank them again for participating and being here to present to us today on understanding the psychosocial risk regulations in Australia. So Adam, I'll pass over to you.
Great. Thank you very much, Michelle. When I'd be grateful if you could take Noella off mute as well, just so that she, unless Noella, you're already on mute yourself, I want to make sure Noella can jump on. Yep, there you go. Yep. Great. So look, welcome everyone. Hopefully this is of interest to you. It's an area that we are seeing a lot of activity in at the workplace, but also in terms of regulation, changes to legislation. And some of these changes, as we'll step through them in Australia at least, are quite significant. And we are already seeing those changes have an impact on issues that arise in the workplace and how employers deal with those issues. And these are workplace health and safety issues, but they're general employment issues as well. And they arise often in the context of performance management, conduct issues, termination of employment, etc. So it's important to understand that. Next slide, Michelle. So in terms of what we want to cover today, we want to step through the Respect at Work legislative reform. That reform arose out of several reports. A report in 2019, the Boland report, into these issues around psychosocial hazards and harassment and bullying. And then a subsequent and probably more well-known report in Australia, the Respect at Work report produced by Kate Jenkins in 2020. Since then, there's actually been several other state reports. Here in WA, there was a report commissioned that was directly covered these issues in the fly-in, fly-out work sector, which is obviously a significant part of Western Australia, and certainly other parts of Australia. There's workforces who are impacted by that. These reports identified a number of fairly significant issues. And I think in the context of what's happening in society, the law is catching up. Clearly, with the Me Too movement and the unfortunate incidents of sexual harassment within corporates and then within the public sector, within the courts, within Parliament. Those of you would have heard about Brittany Higgins and the unfortunate issues that arose there. This has all triggered the change in legislation and the need for Parliament to regulate and legislate to prevent these hazards and to identify a system to deal with them. We'll provide, we'll step through those laws. Then what we will also do is talk you through what we think the employers need to do to deal with them, and try and give some practical examples of how these issues can be dealt with. Next slide. So this is a significant issue in all Australian workplaces, and that was identified in the reports I've just mentioned. It's easy to see workplace health and safety as an issue that relates only to physical health and safety, and traditionally this practice area has dealt with workplace injuries, illnesses, and unfortunately deaths. But the law has always covered mental health issues and mental illness as a workplace health and safety issue. It's just that the the law, I think, has now realised that we need to get more prescription around how we deal with those issues. And these issues arise, the physical safety issues have always been obvious in places like construction sites, mines, factories, etc. But in the modern workplace, or the tertiary sector, where we've got office work and people are not necessarily on tools per se, there are certainly also workplace health and hazards, and they're not trips, slips and falls. The big issue these days is around psychosocial hazards, and so that's what this presentation is going to focus on and what we're going to cover off. Obviously, there's increased government scrutiny on this, and there's prescriptive regulation, and we'll step through that prescriptive regulation. But what the touchstone of all of this is what is psychosocial hazards, okay? And we'll step through some examples of those. There's obvious ones like sexual harassment, workplace bullying, which I think are quite well understood and have been traditionally fairly heavily regulated. There's more regulation that's coming and has recently been adopted. But what's more interesting are some of the examples that Michelle called out, which are definitely called out in the Australian legislation, around things like low job demands, high job demands, remote working, the potential adverse impact of organisational change and restructuring, interpersonal relationships. And these are all soft issues in a workplace, but they are issues that employers now need to be more across. We talked about this, Michelle, when we were in Singapore. COVID and the pandemic and the change in work has had such a massive influence on how we work, particularly those of us who work at a desk. And I think as a result of the change in work, more remote working, doing what we're doing now, there's a lot more focus and understanding of mental health issues and how people deal with challenges. We know a lot more about our colleagues and our employees' personal lives. That's just part of what goes on. So I think the law is catching up with that. Before I throw to Noella to get into some more of the detail, the one thing that I think is worth mentioning, and those of you who were listening in Singapore, I recall giving the example, where we're seeing the rubber hit the road on this is not just in compliance, policies, training, but also these issues are coming up and are being used by employees when bringing claims against their employers. So in 2018, we had an example of, I won't obviously name the client, but we had an example of a software vendor, multinational company, largely working from the office in an office environment, technology work. There was some complaints about workplace bullying, unfortunately, from senior managers within the organisation. They then, those complaints were investigated, we gave advice, and ultimately we had to assist the client to deal with the employment issues that rose out of them. But what was interesting, and thankfully I foreshadowed this, admittedly I thought it was a theoretical risk, but what I foreshadowed and what came to bear was that someone made a complaint to WorkSafe New South Wales about this bullying behaviour, and that led to an inspector coming on site and commencing an investigation. Now, I personally thought at the time, I thought that was a low risk, but I had to call it out. I did, and what do you know? It happened. And since then, we've had other instances where workplace issues around bullying and harassment have also triggered workplace complaints to regulators and have triggered investigations. Now, thankfully, in that case, we were able to assist the client to explain the behaviour, and the investigation did not proceed. But that's not always going to be the case. So it's worth understanding that this isn't just a work health safety issue. It's also a labour and employment issue. So next slide, and I might throw to Noella for the next group of slides.
Thanks, Adam. Hi, everyone. So Adam's already touched on the context behind what we're talking about today. But so the first thing I'll talk through in more detail is the changes regarding the respect at work laws. So in March 2020, the Sex Discrimination Commissioner, Kate Jenkins, released the Respect at Work Sexual Harassment National Inquiry Report 2020. This report found that sexual misconduct is widespread across Australian workplaces, and the complexity of the legal system makes adequately addressing the issue very difficult for both workers and employers. And the report basically identified that the current legal and regulatory system is no longer fit for purpose. So it made 55 recommendations, including in relation to legislative reform, namely to improve the coordination, consistency and clarity between the anti-discrimination, employment and work health safety schemes. Having the Australian Human Rights Commission conduct a national sexual harassment survey every 4 years, requiring all Australian governments to have gender equality strategies that address sexual harassment and recognise that it's driven by gender inequality, and also response mechanisms, including for bodies like the Australian Institute of Company Directors, in consultation with the Workplace Sexual Harassment Council to develop education and training for board members and company officers. Next slide, thanks, Michelle. The Respect at Work legislation of the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Act passed following the release of that report. So that was on 28th November 2022. And that act implemented many of the recommendations from the report. Around the same time, there was a survey conducted by the Australian Human Rights Commission into workplace sexual harassment, which found that 41% of women and 26% of men had experienced sexual harassment in the workplace in the last 5 years. 1 in 5 people had been sexually harassed at work in the last 12 months, and 37% of the people surveyed thought that their organisation should actually be doing more to address sexual harassment. So given the findings of the survey, it was actually pretty timely that the new laws were introduced. So hopefully they will work to address these issues. Next slide, thanks. The key change introduced by the Respect at Work Act is the introduction of a positive duty into the Sex Discrimination Act to eliminate unlawful sexual discrimination. This positive duty requires employers and persons conducting a business or undertaking to take reasonable and proportionate measures to eliminate sex discrimination as far as possible, sexual and sex-based harassment, and hostile work environments and victimisation. Next slide, please. In considering whether a duty holder has taken reasonable and proportionate measures, matters like the size, nature, resources of the business or undertaking, the practicability and the cost of eliminating the conduct will all be taken into account. So some practical steps include things like making policies, providing support and training for employees, and collecting and monitoring data. This preventative duty mirrors the existing work health safety duty for PCBUs to take all practical steps to ensure worker health and safety. In addition, the Respect at Work Act amends the Australian Human Rights Commission Act to give the Human Rights Commission more power. So the AHRC can now monitor and assess compliance with that positive duty by coming to the workplace, conducting inquiries, issuing compliance notices, and entering into enforceable undertakings. In addition, representative bodies will also be able to make applications, for example, to the Federal Court on behalf of people who have experienced unlawful sex discrimination. So the passage of the Respect at Work legislation builds on the changes that were introduced by the previous Morrison government in 2021, which amended the Fair Work Act to include a new anti-harassment jurisdiction, introduced definitions of sexually harassed and sexually harassed at work, and clarified that sexual harassment can be a valid reason for dismissal. So those are the initial changes introduced by the Morrison government. And then when the current Albanese government came into power, it implemented all of the report's 55 recommendations. So including other legislative changes, education programs, and data collection processes like conducting surveys. There's actually a 12-month transition period before the positive duty becomes enforceable by the AHRC, but workplaces are urged to implement changes now so that people can just start enjoying safer workplaces free from sexual harassment much sooner than 12 months' time. Next slide, thanks, Michelle. In addition to the introduction of that positive duty I was just talking about, the Respect at Work legislation makes 3 other key changes. I'll quickly just touch on them now. The first is that it prohibits conduct that subjects another person to sexual harassment or a workplace environment that's hostile on the grounds of sex. This is within the Sex Discrimination Act. Hostile on the ground of sex means a reasonable person, having regard to all the circumstances, would have anticipated that the possibility of the conduct resulting in the workplace environment being offensive, intimidating or humiliating to a person of the sex of the relevant individual. So this new provision doesn't require the harmful conduct to be directed towards someone in particular. It's more intended to capture the environment of the workplace. So it's like a sexually charged or hostile work environment. If there's, conduct of someone displaying obscene materials, general sexual banter, innuendo, offensive jokes, things like that. It's more about targeting the actual environment rather than conduct directed to a person. The second thing is that the new laws provide the Fair Work Commission with expanded powers to deal with sexual harassment. So people can make applications for stop sexual harassment orders. And the third is that it lowers the threshold for sex-based harassment by requiring conduct to be demeaning rather than seriously demeaning, which is what it was previously. So this ensures the provision doesn't impose an unnecessarily high threshold on applicants making claims. Next slide, thanks, Michelle. In addition to the Respect at Work laws, in December last year, the federal government passed the Fair Work Legislation Amendment Secure Jobs Better Pay Act, also known as the Secure Jobs Act. This introduced significant changes to the Fair Work Act around things like enterprise agreement making, pay secrecy, the use of fixed term contracts, and addressing the gender pay gap. Relevantly, the Secure Jobs Act implements the remaining recommendations from the Respect at Work report, including a new prohibition on sexual harassment in connection with work. And this acts in conjunction with the positive duty under the Respect at Work Act. It applies to existing workers, prospective workers, and includes sexual harassment by third parties as well. And it also makes principals vicariously liable for acts of their employees or agents, and again gives broader powers to the Fair Work Commission to deal with sexual harassment disputes. There's now an express prohibition for a person to sexually harass someone in connection with work, and a person can make an application to the Commission for a stop sexual harassment order or an application to otherwise deal with the dispute. And this has been effective as of last month. The stop sexual harassment order is intended to stop future harassment, whereas an application to otherwise deal with the dispute remedies past harm caused by harassment. And this process requires the Fair Work Commission to deal with a dispute within 14 days of receiving an application by way of a conciliation or a mediation. The parties can then arbitrate by consent or make an application to the federal court to deal with the dispute. So this sort of reflects the existing anti-bullying anti-bullying jurisdiction, which allowed people to seek orders for stop bullying. There's also been other minor amendments to the anti-discrimination provisions in the Fair Work Act to reflect other Commonwealth anti-discrimination laws, to include breastfeeding, gender identity, and intersex status as 3 new grounds of protection against discrimination. And this is in addition to the existing grounds like race, colour, sex, sexual orientation, age, disability, religion. So this is intended to further enhance the protections for women, transgender persons, and people of intersex status. So that was an overview of the new legal framework in which we're operating in relation to sexual harassment. And the effect of these changes is that employers now have an opportunity to view sexual harassment through a very different lens and take more proactive measures to create a more positive workplace culture. The emphasis on a complaints-based model has shifted to one where employers now actually have to take action and continually assess and evaluate whether they're meeting the requirements of the positive duty. Adam mentioned before he'll talk through the more practical steps of how employers can comply with these changes, but just before we get there, I'll run through the psychosocial hazard changes in more detail. So next slide, thanks, Michelle. So separately, but sort of related to the respective work reform, is the framework governing psychosocial hazards in the workplace under the various states' work health safety legislation. The WHS framework acts in addition to the Federal Fair Work Act and state and federal anti-discrimination laws. Interestingly, workplace psychological health and safety has not typically been very well understood or managed by employers and organisations in Australia. This is largely due to the fact, I think, it hasn't really been seen as a typical safety issue like a physical injury or a fatality. Psychosocial hazards are inherently broad, and there's several hazards like bullying, harassment, and interpersonal conflict have typically been understood as HR issues only, not so much work health safety issues. In addition, there's also a broad array of issues that can harm mental health, and it's been acknowledged that a lack of clarity in the WHS laws about how to actually manage risks and hazards associated with psychological health has also contributed to a very poor understanding by employers in relation to psychosocial hazards, the WHS issue. So just looking at some definitions, a psychosocial risk is a risk to the health and safety of a worker arising from a psychosocial hazard. A psychosocial hazard is anything in the design or management of work that may harm or increase the risk of harm to employees' psychological or physical health. And I'll go through some examples shortly. But you'll see when we go through it, it's a very broad-ranging list. And as a result, navigating psychological health and safety as a workplace issue can be very complex. In addition, psychosocial hazards can interact or combine to create different or even higher risks to someone, basically compounding the risk of harm. The law now requires the PCBU to eliminate psychosocial risks, or if that's not reasonably practicable, to minimise them as far as reasonably practicable. So this requires a consideration of reasonable measures that can be taken to identify risks and implement effective control measures. Next slide, thanks, Michelle.
Noella, I might just jump in there just for the benefit of those who aren't aware. A PCBU is a person conducting a business or undertaking. And the significance of that is that work health safety laws impose obligations not only on the employer, but on the PCBU. So that means you, as an organisation, are responsible for the work health and safety of not only your employees, but your contractors, other people who are on sites that are controlled by you. And so that's just in case anyone's not aware of the term, it's a broader definition, essentially a broader definition of employer that encapsulates all of the different categories of people for whom you're responsible. So in a contractual chain, you can be responsible for a contractor and then a subcontractor and a subcontractor of that subcontractor, if they're all within your control. So sorry, Noelle, I just thought in case anyone's missing that.
Thanks, Adam, that's great. So I'll just talk through some examples of psychosocial hazards. As I mentioned, it's a pretty broad list and some might shock you, but bear with me. So we've got job demands. So these are things like intense or sustained high mental or physical or emotional effort required to do a job, unreasonable or excessive time pressures or role overload, high individual reputational, career, safety or financial risk if any mistakes occur, or shifts or work hours that don't allow adequate time for sleep and recovery. Low job control is things like where a worker has very little control over the aspects of their work that they're doing, for example, hours or when the job's done. They've got limited ability to adapt to the way that they work to changing situations. there's, might be prescriptive processes which do not allow workers to apply their own skills and judgment, or, levels of autonomy that are not actually matched to a worker's abilities. For support includes tasks or jobs where workers have inadequate support to do the job, so they don't have practical assistance or emotional support from managers and colleagues, or they're not properly trained or not given the right tools or resources to do their job. Lack of role clarity includes uncertainty, frequent changes, conflicting roles, or ambiguous responsibilities and expectations of the job. Poor organisational change management. This is insufficient consultation or consideration of new hazards or performance impacts when planning for and implementing change in a workplace. Insufficient support or information or training during periods of change, or not communicating key information to workers during periods of change. Inadequate reward and recognition includes jobs with low positive feedback or imbalances between the effort put in and the recognition given. High level of unconstructive negative feedback from managers or customers, or low skills development opportunity or underused skills. Poor organisational justice includes inconsistent, unfair or discriminatory or inequitable management decisions or application of policies, and poor procedural fairness. Next slide, thanks, Michelle. The list goes on. Traumatic events and material, I think that's pretty obvious, but things like experiencing fear or risks to someone's health and safety or the health and safety of others, exposure to natural disasters or injuries or fatalities, even reading, hearing or seeing accounts of traumatic events, abuse or neglect. It also extends, interestingly, to supporting victims or investigating traumatic events, abuse or neglect. Remote or isolated work, so working in locations where there's long travel times, access to help or resources is limited or difficult. Poor physical environment, so this is exposure to unpleasant hazards. Violence and aggression, obviously aggressive behaviour, violence, yelling, physical intimidation, that includes such behaviour from workers, customers, patients, clients. Bullying, repeated unreasonable behaviour directed towards an individual or a group that creates risk to health and safety. Again, including bullying by patients, clients, visitors, other colleagues. Harassment, including sexual harassment, harassment due to personal characteristics, age, race, nationality, sex, religion, intersex status. Again, sexual harassment, any unwelcome sexual advance or request for sexual favours, or any other unwelcome conduct of a sexual nature, or any sort of other harmful behaviour that doesn't amount to bullying, such as single one-off instances of behaviour but creates a risk to health and safety. And the last one on the list is conflict or poor workplace relationships and interactions. So that's, the interactions between clients, customers, colleagues, and also includes things like inappropriately excluding someone from work-related activities, which happens quite frequently, I think. So, like I mentioned, it's a very broad list. And I think that a key point to make is any sort of perceived difficulty in actually navigating these issues is not really an excuse for an employer in failing to meet its legal obligations and the consequences for not getting it right are actually quite significant. There's large penalties associated with failing to meet obligations for worker psychological health and safety. An example of this, there was a decision which you may have seen in the media a couple of years ago. It was Kosorov in the state of Victoria, where the court found that a Victorian Office of Public Prosecutions failed to provide Ms. Kosorov with a safe system of work, which exacerbated her psychiatric illness. She was awarded damages of $435,000. So yeah, quite significant consequences for not getting it right. And I think just even, that aside, poor mental health in workers in the workplace contributes to negative culture more broadly and inhibits productivity and increases staff turnover. Next slide, thanks, Michelle. So just before I hand over to Adam, I'll just quickly run through what's happening at a state level down here in Australia. So Adam mentioned the Boland report was released in 2019, which reviewed the content and operation of the model work health safety laws and recommended enhancing the work health safety framework by making regulations to expressly deal with psychological health. So the state's responding accordingly. In New South Wales, they've implemented the WHS amendment regulation to amend its existing regulation from 2017. These changes, which became effective in October last year, provide clarity on the meaning of psychosocial hazard, psychosocial risks, and introduce specific control measures for dealing with those hazards and risks, as recommended by the Boland report. And it makes explicit that a PCBU must manage psychosocial risks in the same way that it does manage risks to health and safety, or physical risks. Next slide. Victoria is a state which has its own work health safety laws. It's not based on the model laws which other states are based on, but they've released an exposure draft of the Occupational Health and Safety Amendment psychological health regulations, which introduce 3 main reforms, including the imposition of express duties on all employers in Victoria to identify and control risks associated with psychosocial hazards, periodic reporting obligations for medium to large employers. So they basically have to report to the regulator any complaints or incidents of psychosocial hazards, and introduction of penalties for non-compliance as well. These proposed laws are expected to commence later this year. And in addition, the Victorian government has actually announced it will restrict the use of non-disclosure agreements for workplace sexual harassment cases, which has historically been a common practice. This follows several states in the US which have passed legislation on this issue in that they won't be using non-disclosure agreements. But Victoria is the first state in Australia to actually commit to doing so. Next slide, thanks, Michelle. As Adam mentioned before, in WA, we've had an industry-specific inquiry into the FIFO mining industry, which released a report called Enough is Enough, which basically found that the mining industry has perpetuated a culture which fails to protect women from sexual misconduct. That report, again, made a number of recommendations, including addressing gender and power imbalances in the industry, establishing internal and external options for reporting, and establishing forums to assist victims. WA state government has announced it supports all of those recommendations and has made a number of commitments to implement them. Lastly, Queensland. The government has introduced is introducing a new code of practice to deal with psychosocial hazards at work, and it's also amending its work health safety regulations to provide clarity on the meaning of psychosocial hazards and risks, and introduce an express duty to manage those risks and determine the appropriate control measures. So that was an overview of the key changes of the work health safety framework on psychosocial hazards. It's likely we'll see further changes be implemented, but in the meantime, there's probably going to be heightened regulator vigilance and enforcement action in connection with the new laws and the new positive duties on employers and PCBUs. I'll hand over to Adam now to talk about practical tips for employers. Thank you.
That's great. Thank you very much, Noella. I think it's fair to say that this is a slightly overwhelming. We talked about this, Michelle, when I saw you last in Singapore. It can come across as anything and everything is a psychosocial hazard. And for those of us, if any of you have worked in a private practice law firm, we've sort of ticked through the list and said, wow, certain industries and certain sectors tick a lot of boxes on this. But obviously the obligation, the primary obligation is to eliminate the risks that arise out of these hazards. But it's also there's also an obligation to take reasonable actions to seek to prevent them as well. And so that's really what I want to focus on here is to say this is quite overwhelming. There's a lot that people need to be aware of, but there are practical steps that employers can take to comply with their obligations under work health safety law, and at the same time to comply with the changes that have been introduced, particularly around sexual misconduct and harassment in employment legislation, discrimination legislation. So a lot of these things go together, and a lot of what I'm going to talk through for the next sort of 15 minutes will assist you in ensuring you comply with both work health safety and labour and employment and discrimination laws. So in terms of what employers and organisations need to do, they clearly need to understand the changes and be aware of them. That's part of what we've hopefully been able to do for you so far. In terms of practical steps, the key things, as has traditionally been the case with workplace health and safety, is the touchstones of that are consulting with employees about identifying the issues, consulting with employees about policies to deal with the issues and to deal with the risks, rolling those policies out, consulting in relation to the policies, conducting training, and I mean regular training and thorough training, not check the box training. We've done some of that recently for one of our clients specifically in relation to psychosocial hazards and these risks around sexual misconduct. We conducted training both at the management level, because there's slightly different responsibilities for managers, and then also at the rank and file level. But that's something that employers definitely need to do. And then when issues arise, and unfortunately they do, I wouldn't have a job but for that, nor would you, they need to be properly investigated, and action needs to be taken to deal with the employees who've engaged in it at the employment level, but also to monitor and correct issues in systems and processes to try to minimise the risk of that happening again. There's obviously significant repercussions for failing to comply. Interestingly, in Victoria, which is a standout, as Noella mentioned, there's going to be an obligation to report a particular incident, which is quite significant. It's still not clear if that obligation will pass in law. It has surprised and alarmed employer associations who are lobbying the government in relation to that. Obviously, the ramifications also for fines and penalties under work health safety law. And just to be clear, there's the risk of personal liability for directors, officers and management who are dealing with these issues. So that tends to get the attention of our clients, and I'm sure it'll get the attention of the business units that you look after and support. In terms of practical compliance, I'll step through some of our suggestions on how you can deal with these issues. But it's really important, I think, to be on the front foot and be ready to deal with the issues, and also be ready to deal with any inspection or investigation that might happen from a regulator. You need to have a defensible position in relation to these issues. And that will come back to, as I said, having consulted properly with employees, having developed and rolled out policies, having conducted training in relation to those policies, and then implementing them and dealing with issues as and when they arise. Next slide. So some of the things that employers can do is look to organisational leaders to take a lead role. They need to be role models. They need to lead by example. There should be organisational knowledge about the issues. So that's not just regular training. It's training and adopting different approaches. It's keeping a record of incidents and issues and risks, monitoring those. As I said, conducting a risk assessment and being transparent. And for example, on the model that Safe Work Australia recommends for sexual harassment as an example is, under their code, is to say you need to identify the risk, you need to assess the risk, you need to control the risk, and then you need to review the risk thereafter. Turning to the other part, to the right side of the slides, looking at the culture of your organisation, considering carefully and thoroughly gender equity and diversity issues, having inclusive management, things like, as Noella touched upon, having people involved in things in an inclusive way. Unfortunately, fortunately or unfortunately in Australia, alcohol is often a part of office and firm events. I think it's important that that not be a part of every event. In fact, the less the better. As I have quipped before, we often get busy in January dealing with issues that arise out of Christmas parties, and that's often because of alcohol. So it's something that in this part of the world needs to be monitored and carefully considered. There needs to be support, and that can be through management, that can be through mentors, it can be through you and your HR function, and it can also be through employee assistance programs. As I said, there needs to be reporting. It needs to be clear in it, and there needs to be a clear and unambiguous process for raising grievances, dealing with those grievances. And measuring is really around keeping records of these issues as and when they arise, such that you have a data set to consider and look for areas for improvement based on things that do work, things that don't work. Next slide, please, Michelle. So in terms of sexual harassment, again, using that as an example, I think it's important to have a good practice reporting framework. And the following principles, these all seem trite and pretty obvious, but they are guiding lights in terms of how you can have a process to reduce the risks that arise out of these hazards. So the process, the reporting framework needs to be accessible, clear and simple. To the extent there's issues, they need to be dealt with in a timely fashion. However, it needs to be a measured response. There needs to be transparency, but as we know in the HR context, there are some limits to that. And often a complainant will say, I'd like to keep something confidential. Unfortunately, that's not always going to be the case, because there are overarching duties and obligations that are imposed on employers. And sometimes the nature of the complaint needs to be shared with others such that the employer can comply with their obligations. In terms of reporting, there needs to be multiple avenues, not just a manager or an office manager, but HR, employee assistance lines or hotlines, or even employee assistance programs if they're set up that way. There need to be clear resolution pathways. They can be set out in policies, and then those policies and those pathways, the pathways set out in those policies can be explained in the course of training. There needs to be clear outcomes and consequences. Now, we all know that, and we regularly give advice to clients on these issues, is you can't explain everything that's gone on in the context of a report. But we all know it's important that if an investigation comes up, there needs to be an outcome and there needs to be communication about that. And if there are disciplinary consequences for the individuals, obviously they will be told about that. But it's often worth considering, at least telling others, particularly complainants, that something has been done. There'll be limits to how much you can say about that, but you certainly need to show that you've done something and you've taken appropriate action. The approach needs to be obviously people-centred. You need to consider the well-being of those involved. You need to ensure that you actively prevent victimisation, and that's through policies, but also through action. And as I mentioned, you need to be careful about confidentiality. Next slide. So in terms of the steps, and this slide sets out, really follows the process that you would normally deal with or follow in the case of all workplace hazards, not just psychosocial hazards. So this has been enshrined in legislation and should be familiar to those of you who have responsibility for dealing with workplace health and safety issues. But obviously in the context of psychosocial hazards, you need to identify the hazard. That requires you potentially to consult with workers and for HR to review behaviours and how work is conducted within your workplace. You need to assess the risk, and you can do that in terms of duration. consider frequency and the severity of issues as and when they can arise. Control the risks. I'll come to in a slide or two some examples of how to do that and manage that in the context of psychosocial hazards. You obviously then need to review the control measures to test that they actually work and that they're actually doing something. And there should be a record kept of the risk management process and outcomes. On that, what I would say is that to the extent there's a legal element and there's risk of legal claims, consider getting lawyers involved. It will sound self-serving for me to say so, but the benefit is that you will at least give yourself the option to maintain legal professional privilege over any advice given in relation to these issues. Privilege will not always prevail, but if you don't consider it and set up an investigation process with the protection of legal privilege, you'd never give yourself the option of relying on privilege to prevent a regulator or a claimant getting access to prejudicial material. It's slide. So in terms of getting a little more granular on the previous slide, it's important to identify the particular psychosocial hazards. And the risks that the psychosocial hazards create through mechanisms can include anonymous surveys, observation from HR, consultation with HSRs as health and safety representatives, or committees, review available information through industry bodies, through ILO, through Safe Work Australia, through your local safe work regulator. They have codes and guidelines that will assist you in identifying the risks within your particular organisation. Once you've done that, you need to assess the risks, and you can do so through an internal or external method. You can engage others to assist you with that. There are professionals in the work health safety space who can come in, look at your organisation, look at what goes on in your organisation, assess the hazards, assist you to identify the risks, which then allows you to go to the next step, next slide, which is to control those risks. And control allows you to eliminate those, will allow you to eliminate those so far as reasonably practicable, which is the test that we mentioned earlier. But you need to control, the control measures need to be tailored to the size of your organisation, the nature of work, and the type of work that's conducted and the activities that you engage in as part of your business. So the control measure will necessarily depend on the particular psychosocial hazard. Next slide. So as I mentioned, the control measures really depend on the nature of the psychosocial hazard. And we've just picked 3 examples, not what I'd call traditional examples of psychosocial hazards. The obvious ones are sexual harassment and bullying. I think everyone, most companies should or should have policies that deal with those psychosocial hazards, and it's relatively well known. However, high job demands, it's easy for you to say, well, wait up, we're all busy. How do we deal with this? Well, some of the ways that it can be dealt with is to plan shifts for employees to allow for adequate rest and recovery. Make changes to the physical work environment, so quiet spaces for people to do mentally challenging or demanding work, quiet rooms if you have an open plan office. Us lawyers are probably the last bastion of the offices, so we tend to get our quiet space, but I appreciate most businesses open and operate in open plan environments. So that's a way to potentially deal with that. Set achievable performance targets, be realistic. I mean, a lot of this is just common sense, right? For remote and isolated work, consider implementing communication and buddy systems. Have training, information, and instruction about the risks that people will face, or the hazards that people will face, and the risks that arise from them. So, give people tools to deal with, maybe loneliness while they're away from family or friends or their children. Think about having support networks to ameliorate that risk. For organisational change, which is stressful for employees and employers for that matter, have appropriate consultation in place, genuinely consider the views of employees, and plan adequately for changes. You're obliged to do that at law anyway, so none of this is new. Next slide, Michelle. So the final two steps, and I can flip through this fairly quickly because I prefer to focus on sort of rounding out on the employment issues, but obviously you need to review the effectiveness of the control measures. These review mechanisms can be through inspections, workplace consultation, HR, HSRs, health and safety representatives, health and safety committees, and analysing the records and data that's collected. It's important, as I said, to also record the risk management process and the outcomes so that you can learn from your mistakes. Next slide. So the consequences for non-compliance can be fairly significant. In the work health safety sense, there can be the regulator can inspect your sites, conduct an investigation. They can then issue compliance notices or enforcement notices, and you can have to enter into enforceable undertakings. And worst case scenario, there can be prosecutions, and that can be means fines and penalties for the company, and also for there can also be fines and penalties personally for directors, officers, and very senior managers. Apart from that, there's also the stress of dealing with this. We've had to help clients with this. It is stressful having a regulator digging into your company affairs, because not only are they looking for these issues, if there's a complaint about these issues, they won't be just focused on that. They will check out other health and safety issues. So the example I gave you at the beginning, the regulator, while they're on site, thankfully didn't investigate the workplace bullying issue, but did pick up that a bunch of the tower cables were non-compliant and had to be fixed. I mean, that was a minor example, but there's a risk of it. There's more.
Adam, we have a question, and I know that we're over time. The question is a good one, and that is, many of our companies here are multinational companies and operate matrixed environments where the managers of the people are sitting outside of Australia, but they are the functional manager of the person. Are they covered under the PCBU?
Yes.
So are they responsible even though they're not sitting in Australia?
Yes,
okay.
Absolutely. And the training that I mentioned we conducted only a week or two ago, we got the managers from offshore to participate in the training, as well as the Australian managers. So this is you don't get a leave pass by being outside of jurisdiction.
Thank you, Adam. And I'm sorry that we're running out of time. So I'll.
No, that's okay. I've literally got 2 more slides.
Perfect.
And then we can wrap up. So really the issue then, what I wanted to end on before I wrap up was really around the employment issue and the potential claims. So if employers don't get this right, they run the risk of sex discrimination claims under the Sex Discrimination Act. There's state legislation as well, or they can end up with general protections or unfair dismissal claims where there's termination involved. They are significant to deal with. The remedies for those include reinstatement, and some of them have uncapped damages. So they are significant, give rise to significant risks for employers. As I mentioned, there's the risk of regulator activity investigations. That the remedies can be, as I said, significant reinstatement, uncapped damages. Now, there are defences available, but the bar on those is very high. So, for instance, under the Sex Discrimination Act, Section 106, an employer can avoid vicarious liability, but only where they have taken very active steps to prevent the behaviour. And that means regular training. So that means having policies, regular training, conducting investigations. And that's a very, very high bar. So it's really important for employers to be aware of these obligations and to nip in the bud any issues. So last slide. So no surprises. I will end by saying psychosocial hazard and sexual misconduct are an unacceptable feature of Australian workplaces. The law has changed and organisations need to respond. The best way I can say it, a little more colloquially, is get with the program. It's not woke, it's the law. And you will have managers who think it's woke. you need to tell them it's the law, and there are significant consequences for failing to comply. Prevention is always better than cure. Have appropriate policies and training in place, and take a proactive, people-centered approach. That's the best way to deal with it. It shouldn't be set and forget. It should be revisited and checked on a regular basis. And I have reached the end of the slides.
Adam, thank you so much. Now, I know we've gone over time, but everybody who's still here, which is a good number of people, please, I'd like to open it up for questions. When can people unmute themselves, or do we need to unmute people? If anyone has any questions.
They can unmute themselves.
Thanks, Wayne. So if anybody has any questions, please unmute yourself.
No.
No, well, you may have done such a good job, Adam. That we've got
I'm sorry, I have one quick question. This is Sarah Hanley speaking from Australia.
Hi, Sarah.
Hi, I'm just, I work in a company which is a retail store environment, and you talked about third parties, or, you know, we would have staff who could potentially be exposed to sexual harassment through customers.
Yes.
What is our sort of, you know, liability, and what do we need to do there in those instances?
Yeah, look, you are potentially liable for any sexual harassment occurs at your workplace, including by customers, as Noella mentioned. I mean, the question is, how do you deal with that? And I think it's important to have, you know, some organisations have clear policies. I know, for instance, when I get on a plane these days, one of the things that the Qantas stewards say on the plane is, you know, we have a tough job to do. Please respect the job we have to do and respect us and our workers. Having some signage around might assist, but also giving employees training about how to deal with an issue, or have managers ready to deal with an issue. Have a process for getting police involved if it unfortunately gets to that level. I think there's some practical things that you could do. Noella, do you have anything to add on that?
No, I mean, similar to your Qantas example, I feel like I'm seeing more signs up in a lot of places saying, you know, inappropriate or aggressive or any sort of conduct, misconduct will not be tolerated. But yeah, I mean, it's I think a difficult one to police, certainly. But I think, yeah, inputting signs like that and making announcements like that is sort of a first step. It'll be interesting to see what organisations are doing beyond that, and perhaps might be a bit more innovative to protect staff.
But perhaps it does come down to, Sarah, the policies and processes that the company does have, and the training. It gives consideration, as Adam said, to the fact that the source of the hazard might in fact be from outside of the organisation, and making that very clear in the policies and the processes for staff that the company understands that and considers it, and that there are processes that they should take when the harasser or the aggression or the hazard is not actually from inside the organisation, but is from, as you say, from clients or customers.
Thanks.
I mean, at its extremist, at its most extreme, obviously, you now see service stations and convenience stores that are open late hours that protect employees by having them essentially in cages. I mean, you'd hope that that's not the way that every retail environment needs to work, but that would have been in response to that hazard and the risks associated with the hazards from third parties and customers. And in those cases, those particular retailers took those steps to protect their employees because of the duty that they had.
Do we have any other questions for Adam and Noella?
Yeah, hi, thanks Adam and Noella, great presentation. It's Phil Saab here, and I'm based in Australia, but I'm actually overseas at the moment with my colleagues. So just want to ask about the psychosocial risk assessment and what that really looks like practically. We're a multinational, we have some parts of our business overseas doing this, for instance, as like a 2-year process, really, because they're getting quite in depth with the assessment phase, doing focus groups, surveys, etc. So I want to get a sense of what your recommendation would be in the current landscape in Australia to conduct a psychosocial risk assessment. For instance, is it getting external parties to do it? Is it having psychologists do it specifically? Yeah, any commentary on that would be great. Thank you.
Yeah, sure. I mean, look, some of the examples, Philip, that you've given, I think they're very good examples of initiatives that can be undertaken to deal with these particular hazards. I think external is going to be helpful because often it's difficult to, sometimes people aren't comfortable raising a hazard within their own organisation, or they're unable to identify it as being a particular hazard as actually being a hazard. So having a independent third party who should have experience across a sector looking at a workplace and having regard to market norms or best practice is a good thing. But it really does depend on the nature of your workplace, Philip. A lot of organisations here in WA, I mean, there's some of the largest functions in the companies, the mining and resources companies here, the HR, the workplace health and safety function is one of the most important functions because the risk is so high given the nature of the work. You need to take, you're not expected to go to the ends of the earth, but conducting surveys, engaging professionals to come in and look at your processes and procedures. And it's not just a desktop review. I think if you want to do it properly, you can't just do a desktop review. You need to get into the weeds. The danger with this is, and it's a balancing act, is, and we've had clients talk to us about this, is the more you dig, you run the risk of actually just triggering claims. So the irony is you're trying to prevent issues, or you're trying to prevent hazards, but you're also trying to prevent issues arising, and the mere conduct of the consultation can in and of itself give rise to claims against the company. So you do need to take a nuanced approach and tread carefully. Does that help, Philip?
Yeah, no, that's really helpful. And I think what reminds me of, I think we would lean towards professionals, because if you start opening up conversations with people about potential psychological risks and mental health,
yes,
I think you can't have that conversation just with anybody. You have to have someone who's able to potentially deal with someone who's currently experiencing a mental health issue and might be triggered by the conversation, for instance.
Yeah, exactly. You wouldn't want to have the consultation. And in fact, one of the presentations I mentioned earlier, I recently gave a presentation to a client to the rank and file. In the context of that discussion, one of the employees raised an issue in the course of the training, right? And it wasn't actually work related. It was unfortunately a personal domestic violence issue that was impacting the employee. But that was not easy to deal with on the spot. So having appropriate professionals to gently, delicately ask those questions in a nuanced way, I think is very important. And if your company's a large multinational, you'll have the resources to do so. And I think it'll be money well spent.
Thanks, Adam.
Do we have any final questions for Adam and Noella? No, look, thank you, everybody. I'd really like to extend sincere thanks to Adam and to Noella for presenting to us today on this. Some of the psychosocial hazards that you mentioned, I know we all sort of our eyes started to glaze over going, my goodness, it's really the scope is so broad. And it's something that is really important for us as employers to understand and to deal with, as Adam and Noella have said, in a way that is procedural and functional, and to really come back to the steps that will help you to address this. So I'd like to extend again thanks. Thank you very much, Adam. Thank you, Noella, and thank you to everybody who's on the call for joining us today. The call has been recorded. We will post the call and make it available, and the slides will be available as well. So thank you very much for joining us. I will give a small advertisement. We don't have the link available quite for you yet, but at the end of May, Adam will join us again with a colleague from New Zealand, and we're going to discuss the changes to the industrial relations environment in both Australia and New Zealand, and have a bit of a chat about a comparison with multi-employer agreements, fair pay agreements, and the differences between the countries. So if that is in your wheelhouse, please look forward to an invitation for later in May. But thank you very much.
Ready, Michelle, and I already sent it.
Ah, perfect. You're ahead of me. I'm not looking at the chat. So thank you very much. Look forward to seeing you all. And once again, Adam and Noella, thank you so much for your time. We really appreciate it. Goodbye,
Thanks a lot.
everybody. Have a good day.
You too.
Thank you. Bye.